Right, omwancho murigere weta TV na inde chinga kishinde chingia na nyarero kwariganiga iga asomoroberio okwana netaya asiritkolia lero lya Jumanne chitariki emeronge bere na ibere mutienyi no yoikomi omwaka gwechirwibere na meronge bere na inye elinde ngende gokomanyi onsi buna ngende to koleka chinsemo ao chinse kobwamono na ase ensemo ye county ya Kisii amone en county ya Nyamira na baigo komanyina na radia ya kobwamono agende to koleka ase ense ya Etaya Kenya kobwamono somo chioria o Nairobi ase buna boni gango komanyina ekegambero kelia kyo gochikoligereria ekina kyo yorenge omokonyi wo murai Rigathi Gachagua ni gondo chegali aba wakili au banyaliko bagwikirana galia ase amagachalia Milimani Law Courts ase liribuna banya toko bagochora 3 judge bench osaba judge batatu au bagochikonyara koligereria igoro yama mochaya iga Rigathi Gachagua ilinde banyaliko bakorwali chibu ase litukolia lero nabo igo narora buna Rigathi Gachagua nere nanyara ko bagawikirana gabo asama gachaywa Milimani Law Courts amo nabara ibande abanga manaba wakili yabo Cleopas Malala oyore senior counsel Paul Mwita mona banda bange banyali kwa bawikirana gabo aseke gambero gabo esomochi Nairobi imeya Milimani Law Courts nabayigo the 3 judge bench oseba libawo chikonyara kuligereria alinganelio Eric Ogola, Justice Anthony Mrima amona Freedom Gambi abuna bawo chikonyara ko baba kuligereria alinganelio lya oyorenge omokonyi wo murai bwense Rigathi Gachagua uyonya tokoba kakoba impeached ekere alenge asenyagetari magega ya yokurwara na kuigwa igekubakia ebororo akanyara ko baga koirwe senyagetari ya Karen Hospital kolende aseri tukoria Jumapili na takoba ga kuigororo kurwese nyagetari kubwamana na nya takoba ka Kwana na goteba na nya takoba ga kwemurungani igoro na ya abantu osena temete goitwa chingaki alenge asobora ibuna omokonyi omurai bwense asekera alenga chinsemo cha Kisumu amone chinsemo cha Nyeri atemete goitwa ange chintunda ibere nabo igondo chena DCI wose Director of Criminal Investigations banya takoba ko mochika elinde anyara ko genda siabo chinena na konyara ko baga kolika enganeyo eyanya to ko baga kwemurungani aseritukelia Jumapili buna nanya to ko baga kagotemwa goitwa asechinga kichalenge omokonyi wo murai bwense arenge no mokonyi wo murai bwense William Samoei Ruto nabo igo aseritukelia rero mwancho morigere ayina to chikonyara ko ba to kumurikira monoko wagali asichinse mochiria cha Milimani Law Courts asendo cheneke gambere kyo ekenene ndo chega limbanya tuko bagoteneni actually oko apishwa kwa Kindiki kidure Kindiki uyonya tuko banereka go ba nominated na omorai bwenso yole William Ruto na boigo akanyara ko ba approved na the National Assembly ritukuliria rengeria Ijuma magega yayo bakamanyara ko korwese kigambere kene tukanyara konyora ogoteneni wa kogo chikonyara ko kumwapisha kidure Kindiki aseri tukuliria kagereteri chikonyara ko lie Jumamosi before bagende ese omojegoria omashujade igo mwancho muri ngo chitoronya ko murekera mange kurwa sensemeli ya Milimani Law Courts elinde tunyara ko manyana nkike go chikonyara ko bakego ikiranwa asendo chena aba wakili amona baraibanda bange banyale ko bago ichora kabisa gabo ase ekegambere kyo kya Milimani Law Courts elinde banyale ko babako ibona na ki abajaji abo batatu bawo chikonyara ko babako na cha ekinekyo yorenge omokonyi bo murai bwense Rigathi Gachagua nabaigo mwancho muri ngo komanyina amatemu a KCSE anyale ko bakago chaka bena seritukolia rero asechinsemo ao esendo chena aborokiwa over 960,000 bawo chikonyara ko bawo ikaransa amatemu ayu abamanena KCSE asendo chena rehearsals tiarenge ese Jumeli ya etachitariki 15 bono amatemu abo anyale ko bakago chaka bena seritukolia rero chitariki chiga meronge bere na ibere ayo uchikonyara ko baga kogenderera goika chitariki emerongo ibere na ibere omotienyuria oikominemo nabo igondo chena amatemu akipsea osa Kenya Primary School Education Assessment naro iga uchikonyara ko baga gochaka ase chitariki chiria cha emerongo ibere na isato wiki go chari tukolia Monday lakini ndo cheri rehearsals chabo chigo chikonyara ko bachigo chaka ase Jumeye iga ya mambiende iga ye chitariki emerongo ibere na 5 asebendo chibawo chikocha kama temwabo cha karitiko lya Jumatatu weekend wikaritiko lya Jumatano wose chitariki emerongo ibere na isano na isato wika chitariki kiria cha emerongo 3 awuna matemwa lya kipsea wosali ya grade 6 na boiga ya KCSE anyale ko bakago cha kabene asichinsemo au asendo chena bagendete buya kolende na mbarororo narora bayibuli bako na gosemiwa nabaorokiwa yani naborokia abuna banyale ko bago make sure abana babo banyale ko bawo ikira na skuru elinde banyale ko bago kora amatemo mancho muri na manga gende tokoleka asichinsemecho au kubwa manona amangana arigadi gashawa na boigo amangana yechisemi amatemo yaga amanene buna gende tokolende kiwasi chinsemo au ngochitoreko gende kubwati amangana ino robot yoru arigadi gashawa elinde tuna kumanyana na aralia agochikonyara ko baga kwene kiwa asichinsemecho kolenda saboni go mancho muri ketoroye kemanyiro gito linde ngendere ko bamanyina na aralia agende tokolende kiwa asichinsemmo au ndoche na ngote bibuna waipa Kalonzo Musyoka waipa leader ndoche nere nanya tokoba kagoteba usenkoligiare ogosirwa kurwase kerwe kawo chikonyara ko banerega kuri yo mwaka 2027 kurwase chinsemo chiri cha Mount Kenya anya tokoba kako basaba buna banyara ko babako musira elinde nere achikonyara konyora ekeroge ekyo ese anya tokwana mangana ya igas chinsemo ichekera lenge ekera goteba buna rigadi gashawanya tokoba kawo ko isiko nere bono nyale ko bagago saba abantu ba Mount Kenya banyara ko bako musira ese kero mwaka 2027 ochiwika kera ba ochikonyara ko bago enda dostoko tochikogenda ase chinsemo cyuwaka chikura nabo igondo chegaiga aba Kenya ko rwa chinsemo chiri cha diaspora ndochina ebagendete ko mwaka Ruto amagena kabisa esabago teba na mbo bakorete tanya itikwa sokia elinde konyara gusira omokonyo ebumurai bwense oyuole ngomokonyo ebumurai bwense regadi gashawa nabo igondo chebago amangana IBC naro banyali ko bago kwanira sengencho na abarai mbai yororo aso IBC nabo igo chitam limits echi abarai banyali ko bago teba na kinyala ko bachikomentwa banyali ko egwa komentwa emiaka kurwe miaka 5 goika emiaka elia 5 wose miaka 5 nebere miaka 7 asobora ibwa bondochina barabuwa banyale ko bakogikiria amangana yu 3 ekorwa se chinseme cyo chia diaspora nabo igo mwancho muri ando chega iga buna toto yande to kobatebe na kobasemi kuruga iga buna esegeta senigeta TV buna chinga kiechiga buna abana usaborokiwa banyale ko bawusieka chiskuru abayibuli anene mono igo bagosemiwa na gokulerwa buna banyale ko babako beka obulendi mono gochiase abana babo buna bale aserusa erentambe sana ko bwa mono ndo chega iga kura sensemelia ya Mount Summit Primary School omwana omumurabu emiaka 5 ne 3 nanya tokobaga konyorwa ase nyumba ya kibara omubero eno nya tokonyorwa roroko ko kasireti obagima bwaye na iga magega yaye yo konyara kobora ase amatuko 5 nomo esanya tokobaga kogenda nabasani baye ase kanisa asensemo ya St Paul Catholic Church kolende na tachieti konyara kobaga kwira na gochinka bakanyara ko baba ko moligia goika buna bachite komanyora ase litkole igoro ka tugutirwa somo beroye kore ase nyumba yo ya kibara eyu yarenge bagoteba very open etabuga ati wose etaga kiri asenchira ere endonge go mwancho muri etoko basaba buna andonsi asole ayabuno moiboli buna abana aborokyo banyale ko bagosieka chisukuru ese bawo chikogenda somo timoko oromo tambe intubuna abayiboli etoko boli gwana gotebigwa buna tunyala koba tokonyara kulinda abana baitu buna bale chinka elinde banyala ko bakobera asenchirere ngia elinde bawo chikoigwa chisukuru ndebe banyorwa namba mbiyabala moiboli andonsi asole na mange ogokule Rwanda onse asole abuno moiboli onyala ko gokoene kina abana mbiyabale ase chinka mwancho muri na manga agende tokoleka kolende koira nande linde ngende okumanyina na raliaya agende tukwana kiwa ase chinsemo au chinse ito ya Kenya ko bwamana na ase orogongo rwa kusi Eliane Nkorokwa Dana Kwamboka Gisoi. Right, omwancho murigere na kwariganirie irinde tujana kugenda gusangana ya mange meyo murobere yo Kwana Netaaya guchakera chinse chiga uika chinsa chiria isano na ibere ndengo gusabano nyako ikaranso ike irinde tunyara kuba tukwana na kurwe birengere bito asobwamo asokunyara gutubwate gwetera se mitandao yetu ya Facebook ama na YouTube no Kwana Netaaya TV na bayi wana bago tulikera ujumbe gwetera se namba yetu yesimiwire gabo ase screen ya 0735333000 irinde tunyara kugenda gusangamo naye meyo murobere yiga Kwana Netaaya ase litko lya lero lya Jumanne bunanega kokote yo mwancho murigereria nigo yolengo mukwanyu muraibwense Rigathi Gachagua anyale ko banerega ko ikira nagalia aseke gambero kia milimani locots amona bawakili ao ase bawo chikunyana ko bagotegerera ekina kia ya Rigathi Gachagua ase banyatu ko bagochora abajaji batatu yore Eric Ogola, Justice Anthony Murima amona Freedom Gambia bawo chikunyana ko bagotegerera ekine kyo kia Rigathi Gachagua kuruga abo banyale ko bakorwa bose banyale ko bakona ekine kyo nimete na abange na baganyerete gabo eni twana kumanya na intubu na bakenya what next esenge nchumwaro chegalia muraibwense William Ruto na nya tokobaga ko mochora Kithure Kindiki esendoche nagalia abajumbe mbanya tokobanera na baroba wa approve elietaria ya Kithure Kindiki asiritukoria Ijuma kolende maega yaye kigambiro kia High Court ekanyara ko bakegotenenia ogwapisho kwa Kithure Kindiki igona na mange agendeta kwene kwa chinsemo au chinse ito ya Kenya kolende gochitoro kwenda kubwatia asenchera yobo ime elinde na togendere kumanyana na ralia agendeta kubwatia buna oroche gabo ase screen gabo abuna sense media ya milimani locots meyo mochi o Nairobi ase togendeta kubwatia na kumulikirana na ralia iga agochikonyara ko baga kogenderera na kwane kiwa korwase chinsemecho chia milimani locots na bayigo mwancho muriyo na batebi na matemu na agendete okorwa kurwase aborokiwa baito bekerasi ekege 12 ose ba form 4 asendo china chinga kiechiga amatemu yagendete kubwamona ya kipsea na batebi ocho chaka weekend kurwa kitariki kiria chia 25 tulitukoria Monday wika tulitukoria Wednesday nindoche na rehearsals chia kipsea chiwo chaka asiritukoria Ijumaa ilikale chitariki emerongo ibere na isano ase wiki yiga nindoche na boigo KCSE ibuna yanyale ko bakego chaka nindoche na omobisabu ekisemi kurwa se sub county ya Kenyanya Gladys Zakari nigo aboretie ko bwaterana egati yabo bisabo borendi abayiboli na boigo aborokyo bonsi asobwamo eliyo kwenekia buna aboroki wango kibale konyara ko baba gukora amatemu abo muchando onde bwensi otayo morikyo itoko Nelias Onyancha na nya tokobaga korosia oroboti rwa senchira ire yobo ikirano
abayiboli cross chibunge chabo machogeni kubanya rekoba kuburi ko nikibuna chinga kechiga abana bakendete kugenda chinga seru sentambe ko nikibuna abana baba nkobera bara chinga chinchira chindonge anene yasogo itanga cross bikorwe bosalibira besikubika magimabo asa kongu.
Jambo moja nataka kuambia wazazi, muwajibike. Watoto wenu wanapokuja nyumbani, kila mzazi ajue kwamba huyo mtoto amekuwa akitunzwa na mwalimu pale shuleni. Kwa hivyo umepokezwa kijiti, hakikisha kwamba huyo mtoto anakuwa salama vile ulivyopatiwa pale shuleni.
Waigomu director yubichisemia se sub county ya Kenya Muswati Gladys Zakari nigonya rekobaga kurukubori kupatra negatia baiboli na bigaba gambi bonsi anene chinga kema temo manene araj kunyara kwa kagochaka.
Msimu huu wa mtihani tunaomba kila mmoja wajibike, sio idara tu ya elimu. Hii ni kazi ya kila mmoja. Tunaita it is a national exercise. Kila mmoja aungane mkono na sisi, idara ya usalama, wazazi, walimu, wote tunashirikiana kwa pamoja ili tuhakikishe ya kwamba wanafunzi wetu wanafanya vizuri. Tumekuwa tukifanya vizuri kama county sub county yetu ya Kenyanya.
Kubatkana mne sub county yoga nreta kokolobya chinsemo chichisemi nigwani kiribuna samatemo y'umwaka yigabo igoni girach kunyara kubakiko kolebya.
We have schools of choice, kumaanisha tuko na mashule ambayo inapendelewa katika Kenya mzima. Kwa hivyo Kenyanya sisi tunataka tuhakikishe ya kwamba watoto wetu watafanya vizuri, ili tuhakikishe ya kwamba ile mark ambayo tumeweka, the top mark ambayo tumeweka tuisurudishe nyuma, tuendeleze kabisa mpaka mwisho.
Na sasa muyende ya bali bamenyeta muno bore mas chinseme chinigo baya Kwana yega.
Wengi wetu hatutambulikani sana. Unakuta wengine wako kwa record, wanapata kitu kidogo kwa mwisho wa mwezi, na wengine wanaambiwa ati wewe sio mlemavu, tunataka yule mlemavu ambaye anakaa chini hata anaenda haja kwa hapa ndio mlemavu.
Ukuburi kwa bankuri buna bali no balema bwichinga nchichonsi banyara kwa babako uligereriwa kwebereka ko nigwensi gutayo.
Naomba wale watu wote wachiwezi wapate njia mheshimiwa ya kusaidiwa, ndio wasaidie watoto wao wale wamepata ama wale wamepata wanalea.
Kwa ripoti kitasingi Etaya TV, Igonkuru kwa Cornelius Unyancha Mugusu.
Right, umwancho mulire na boigo abayibuli na barabuni banyareko bagosemigwa goika abana babange chingakie chiga chierusa entambe yanyareko bakego chaka na boigo ndoche na gokwana chingakie chiaboroki wa class gya kiandana na boigo class keriya 10 nigo banyareko bakoboli una bagochikonyara ko bagochaka omutumuko yega bwerusere entambe umoroki wa manena gwe skuru ya Masego korokuna na Robinson Matara nigo anyareko bagakogania abayibuli banyareko bagotumeka chipe chiabo buja asenchira erengia ase ukonyara kubaga kubalenda abana babo kubwa mono na chipesa chie bonus ye chae eyu yanyara ko bakego chaka Kwana na tikango trai goro gotiro kura somolike to Felix Nyakundi
kago Kwana se abisi yaye chinga kegolera boroki ogo chaso mutumuko bo mwere obo mwakoyo mwalimu monene bwe skuru ye bwana Robinson Matara nigaga nirobore ndio buja chinga kicherusa asekeria mabena manke aragenderere asigika kemetie nyebere
bana baito ba form 1 to 3 to abungire skuru ko yanda barese chinka so mutumuko mutambe sana buno naligereire naligereire bageri gotabanga abayibuli baito na balimo kolenda abana kindly abana bakire chinka ngo cyabajagire ocha chinka nandi gwikengo cyabali chinka moiriri bagali nene yo kugamba nabana baino na koranga kibako cyakerusa asenge ngere rusa entambe nande gutwara emige menge ya December ngo basorora moiriri bagali nene kumanyanga ki abana baino bakomenya ligara bantu twara umucyando kurwase bale gose mbanyoro umucyando ne bwense ligara yasago tukyo mwako goja nando nyoro bayirane bonse to endere kubasomi
abayibori boigo nigo basabire gutumika chibesa cyabo chie bonus ye chae asenchere ndonge na boigo kunyora gwakanira abana babo school fees erio tibacha ko chandeka omwako gocha
nali kunyulia abayibori baitoiga asenge ruseye ebwata mangana mangi yemiga mo basa kweba kende mwanyo watukurose mate chae bonus mutumeke yonzi asoko beka ko soko ligo chinda mwebe school fees nyuranga chanu walingoje na nene ko ganeti nuragera haragere chanu waneka nyene ko ganyita yonari ko basaba asa kusaba konen monte akiri bagali nene kende kwa nyoto ko se bonus oge ndo deposit fees ogajali city chanu walege ko iro mwalimu akoligera liso mwana agenda so chirichira atikaren ko mana ko so kutumia ko se koli lakini mo basa kweba kunangora abana makutaka kweba baji ba basi atumika bobe chanu walege kana baso kwangaika kio nari ko basaba kindly andonje simoli bali monta kemeta chibese chichie cha chikoro kwa bonus kindly mujitumeke buya mujiyakane fees mapema alafu January go iketoke no korte wa kane fees imangana lyako endera kaba korora basole buno moiboli
boigo niko bwana Matarari no kwegenanga aboroki obu mwako yo mbache gweta buya asaba sabire gotanja kungainwa asogo sirigwa na keria konye basomigwe
mate mwafu wa KCS ona aliko ganinga kanelia bana baita maya bana baitu bagusimba kanelia maya na kubatebinga abalimu ntuna abalimu twakorera party yaita bayibuli bakorera party yabo bone yatigere party yenu nainu muikaransa mate muri no bali mokora mate mbumbuya singa nyuri manyetenga twabasomiri buya nantu abapangire buya pono nainu karansa mate no bali mokora mate nigenya saba ekeli mu abere mu koliya semia keyene ni manyetenga mu kimonyora igo twaro bolemu na ende chinga kije mwe bwata buya asenga chinga kije mate mu bwata temptation chinyinge mome akishwanga na inu mwabe utwale discipline eliye kaniri asinga kije matemu abange mbar bakora na bange singa kibune kimo sakonga inu
Right, omwancho murgerera buna naika kobatebya serituko lya lero lya Jumanne nigo ekigambiro kya Milimani Locots banya ko bose bagenderete galia kuigwa ekigambiro gose kuigwa ekina kyo mokonjwe oyo lengo mokonjwe muraibu enseri Gadigashawa ase judge isato bose batatu oyore Eric Ogola amona Justice Anthony Murima na Freedom Gambi bawo chikonyara kwa bago tegerera ekine kyo kya Gadigashawa erinde tunyale kumanyana na kibawo chikonyara kwa bago kina chabunango tebuwa saboni iga banyale kwa bago chaka omorobero yo boko igwa na gotegerera ekina kya Gadigashawa igoti yankoire eyemo aseyemo wikagali ya somochi o Nairobi imeye kigambiro kya Milimani Locots eri ntogenda kubwatia na kumanyana na raliya awo chikonyara kwa baga kwenekiwa kurwase chinsemecho.
His Excellency the President, who has been sued in person and is being represented by Adrian Kamodo.
Yes, for the purposes of clarity, just I will record the column fully.
Dorcas will appear as the Attorney General. For the Attorney General is Professor Gideon Mwigai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Vita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel. For the National Assembly, Eric Gumbo, Paul Nyamodi, and Mugala George. For the Speaker of the National Assembly is Benson Milimo and Josephat Milioni. For the Senate, Professor Ojienda Tom, Senior Counsel, Moni Mukele Edwin, and Senator Hilary Sigei. For the Speaker of the Senate is Mercy Tanji and Peter Wanyama. For His Excellency the President, Adrian Kamodo. For Professor Kindiki, Mudomi Piankolu, Moses Kipkogei, and Ken Levy.
Your Lordships and Your Lordship, my name is Kipe Mongai, appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Person, my lord. Your name, please.
My name is Kipe Mungai. I thought I said it, my lord. Kipe Mungai. I appear in this matter, my lord, with Senator Daniel Manzo.
Present, my lord.
Mr. Ndegwanjiro.
And present.
Honorable Jerry Maina.
Present, my lord.
Mr. George Sankimpa.
Present, my lord.
Mr. Andrew.
Mr. Kibe.
Yes, oh, sorry.
We are recording.
You are recording. Sorry.
Can you start from Dan Manzo?
Dan Manzo. Mr. Ndegwanjiro.
Present, my lord.
Senator Honorable Jerry Maina.
Present, my lord.
Mr. George Sankipa.
I'm present.
Mr. Andrew Muge. Mr. Kirabu Aduta.
Present, my lord.
And Mr. Kenneth Matiba, who is on the way, and Professor Ogada. Professor Ogada.
President.
And Kenneth Matiba is on the way. My lord, we appear in this matter that continues to be referred as Kerugoya, petition number A015 of 2024, that appears to have been filed on the same day.
So you appear for which party?
We appear for the petitioners in that case.
Your Ladyship, this petition E015/2024, Kerugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. My lords, again, let the record capture and show that counsel appearing for the first interested party appear under protest. Counsel are as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigwa, Victor Swanya, George Wandati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigwa, Victor Swanya Ogeto, George Wandati, and John. At the appropriate time, we will be going into the grounds and basis for appearing under protest.
My lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given. My lord,
before Mr. Kikude moves on that file, are there other files, especially file number petition E572/2024?
sit before the bench. We'll take forums for the files which are before the court and that you can raise any issue.
My lords, may you kindly equally confirm whether E0, E5 or 9, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimozo Maingi, petitioner versus Deputy President of Kenya, respondent, and the Honorable AG.
Well, that matter is not before the court.
Your Lordship is being called, it is the call that you know whether it is before the court. We also want to know whether it is before this court.
My lord, so my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether you can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave directions that it should come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. Raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Wambi, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, the files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, your ladyship, we heard the court assistant call out petition E13 of 2024 and she mentioned the word Kerugoya. That is the file that was called. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out E13/24 of Kerugoya before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This
Senior Counsel Paul Newton, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here with E0114. E0114. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. If you there are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them, maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we welcome it, and perhaps also state for record that we also appear in E015 in protest. But further that, Your Lordship, can we confirm that the number that is now registered in the matter that came from Kerugoya is E015? And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kerugoya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file in the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kerugoya or in Nairobi?
Let me deal with that. Lord, for the purpose of A572 of 2024.
That file is not before us.
That's all I'm only saying. I have heard the directions of the bench. The file is not before you. But I have instructions for the purpose of the one to take that petition was filed on 18th of October. The same day the Kerugoya file was filed. All the directions in all these files that have been taken to a graveyard is that None of these files of ours have orders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lord. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you.
Lord, if you could more elsewhere.
I had indicated this honorable court that there will be at least 3 clarifications.
Just a minute to something.
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that they are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why we're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps Justice, to add that it's the numerous other petitions that are coming up
TV Omurabu Wagusi. Etaya TV Omurabu Wagusi. Etaya TV Omurabu Wagusi. Etaya TV Omurabu Wagusi.
There's a column in E013 which was consolidated in Kergoya with E014. Just take column on that file.
Your Lordship is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not had it perhaps to be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The direction from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Murima was giving the clarification, I never heard him clarify whether the Keroboya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Keroboya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
My Lord, may I say something?
Let me answer you. You said that record speak for himself. And for record, matters which came from Keroboya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Keroboya was already consolidated. Those proceedings which took place in Keroboya consolidated these 2 files. So let that not be an issue here. On the directions issues on 11th by Judge Richard Mongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to the Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Keroboya under the Keroboya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Keroboya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Keroboya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kilgoya is this. Going by the orders which were issued by Kilgoya Court, there was a specific order that because of the transmission, parties will still file their documents under the Kilgoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we may now raise the issues that you want to raise, particularly arising from the issues in Kilgoya. And I will then
proceed and take quorum on it. They were consolidated, so we will not take further quorum on this matter.
The Attorney General, I don't know, I have indicated to the court I need to raise some clarification. You had already asserted. It doesn't override my right to represent my client.
I'm repeating.
Can she then say her piece? I say mine.
Now, which matter are we now dealing with?
We have 0 and 15.
My Lord, I want you to say that.
Yes.
The only matter they were filed before impeachment and they have been considered to be we have E15.
E15 has to.
But E13 and E14, although from Kilgoya, they were filed before impeachment and they have no conservative member.
I hope I have then heard without further appearances. My Lord, I'm leading the number of advocates in this matter from Kenyaga, E015.
Kilgoya 15?
Yes, Kilgoya 15.
Yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on the record. We do not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, that you are convened by the Honorable Lady Justice Will, the Deputy Chief Justice. Lady, my Lord, arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice
appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday, I think I have a right to raise those issues.
Let's give my fellow Mungai time.
Mungai.
I just wanted for good order.
Okay, is that a clarification? Mungai.
I am Mungai. I believe he will speak in response as soon as I'm done. Let me finish.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Mungai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's before the court. I should be having silent. He will respond. And I've indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My Lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My Lord, under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made last night. And my Lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My Lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my Lord, arising from that,
that we discharge the directions of empanelment.
My Lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice.
That's what we are indicating. But number two, and it is implied in the applications for disqualifications that we have filed. Number two is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, 3 issues worries us. Number one, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoys special privileges. Number two, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that these issues speak for the wananchi and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my Lord, is this, the issue of bias. And this is bias by the Honorable...
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that does not have to do with those prayers. But the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters, one of them in which I appear, and this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized, it is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My Lord, sir, just to add on what my learned friend has submitted on, with the permission of the president, I wish to say I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get appropriate, there should be no problem. We are all here to defend the Constitution of Kenya. So don't worry. Don't worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
And Council Negula, you know, when you argue the way Mr. Mboy has argued that court start on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court start on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had the samurai. Let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
We haven't really. Is E015 in Kiriboy. The deputy president is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ogoya will be making submission. But my lord, do give us, this is a very weighty matter. This E015 in Kiriboy. The orders of your brother, Mr. Justice Mulibo, were given at 4 p.m. Where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night of Friday? To give them permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of president in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
There's no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go directly to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the three files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4. On the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's where the constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated that 6 file with the lead file 522 have no reasons why they should be before you, noting that your lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, your lordship, that you issued to summon us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, your lordship, most respectfully.
My lord, with your kind permission, for the record, Dr. Kamoto for the fifth respondent in E015. I believe the reason we are here and the reason why we took quorum is because we recognize that there are different parties to these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the audience of the court. So in this regard, my proposal is as follows, that each of the parties whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectively urge that we get an opportunity for each of the parties to ventilate the issues, because the fifth respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the nomination of a presidential of a deputy president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my lord.
My lord, for the first interested party.
Mr. Lord, yes, Mr. I was about to interject when when counsel, Mr. Nokubegaran, yes, was addressing, and that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which...
The application can only come after I have spoken.
We are now making an application, you respond.
Well, what is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165 Clause 4 to empanel this bench. Your Lordship, this is the background of my application. That on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject, seek your guidance. My name is Muzomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes,
my lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform
their duties as head of the judiciary and to interpret Article 165(4). That can only be through a substantive application to which all parties must respond. I think my concern then, Ndegwa and my lion friend Kibe, is that you are taking the court for a long ride and we're ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say?
Well, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your Lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My Lords, if it pleases the court, my name is Jumanne. I am acting in person. We filed an application for a certificate of urgency on the 8th of October 2024. Before this bench was in panels on the 14th of October 2024. Unfortunately, some of the criteria we were seeking have been overtaken by events. My Lord, and today as the heart of our application has not been placed before you, and we are just concerned that our application will once again overtake our application. My Lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my Lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, can I just be heard for 1 minute only? My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We add that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that Mr. Boy applying for an adjournment? Because he's saying, and perhaps wrongly, that even the recusal application comes after the termination of the question on panelment. If that be so, and they may leave, they normally leave court, they leave Senate, may leave court. We let them say whether they are applying for adjournment.
Is that remark, they normally leave court, whether they left Senate, my palatable in this court, my Lord? I need that.
No, because it's an adjournment.
No, is that remark palatable before my Lord and my Lady? But because, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a vague application for adjournment. Because Mr. Boyer is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but he did withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing. Okay, my friend, no, I have no problem, my lord. I withdraw the remark, but
Thank you.
there is practice.
Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and environmental for many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Gibe Mungai, and learned colleague, Mr. Njegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gisoi, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is now. They actually knew of it, and or should have, they would have found out the letter which was written this morning, which it was written on the 20th of October, as actually one pertinent question disposed whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to ECJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. That as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they're trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today.
My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the applications which have been made or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
Etaya TV Oburabu Bwagusi. Etaya TV Oburabu Bwagusi. Etaya TV Oburabu Bwagusi.
I need to graduate. I know my numbers and ABC.
Advent Top School Amaliva nige komanya bunamba bwate omuyigo graduation asabana ba PP2 na kubunge skuru Jumatano tariki 23 omotenye komi mwaka yoiga wochakira chisenye chamambia.
Hi, welcome to Advent Hope School. My name's Madam Vicky. On behalf of our director, I want to welcome you all to our third graduation that will be held on Wednesday, the 23rd. Feel welcome. We will be having a ceremony here at our school. Thank you.
Samange naboko bakeresimia namba 0728 906780 0728 906780. Eskuru enige kutoka Amaliva mutwe ya Kiogoro mwense mwariganigwe. Ine nuganite guchaka uburimi n'ubutugi bw'ekingoko wose koira ibirengo byao igoro bono kampani y'engoko na buri chibu lyago mbabwati ibicucugo cakalitukirimo kuikimeti nyebere ibire chanjo yani bire vaccinated chingoko chimisu ichikobe kamagena guika 280 asomwaka chingoko chioko nyenya chibwate nyama inyansu chitwani cy'umusararo amagana yo uturagia chinkubeta chichisize chionse wochakira amagana 64 goika 20,000 icho boigo chire automatic boigo na wako guturagiria yani hatching services na gokoera chingoko chiago echanjo yani vaccination chingoko chabo niko chibwatu bunyamase teriko chandwa amona marwaire na niko chikokoria bya marakane gwitania chingoko chia butambe niko bago supply no ni byombe nekero